Wes Miliband is a partner with Atkinson, Andelson, Loya, Ruud, and Romo, AALRR, a full-service law firm with over 200 attorneys in 9 offices throughout California. AALRR represents both private and public sector clients with emphasis in the areas of employment, labor, construction, education, real estate, water, general business and business litigation, corporate, and taxation. Mr. Miliband works out of the firm's Sacramento and San Diego offices. He is an environmental lawyer focused on water resources and environmental issues throughout California involving surface water, groundwater, and fisheries issues. Mr. Miliband represents public and private agencies, individuals, as well as a federally recognized Indian tribe. Mr. Miliband started his legal career as a deputy district attorney in Orange County, where he prosecuted 20 jury trials and several more before the court. Prior to law school, Wes was on staff for a member of Congress. He frequently speaks and publishes articles throughout California. More information about Mr. Miliband is available on the firm's website, AALRR.com. Mr. Miliband may be contacted at wes.miliband@AALRR.com or 916-920-6979.
Well, greetings to all. My name is Wes Miliband. I'm a partner at Atkinson, Andelson, Loya, Ruud, and Romo, based in California. And I am here to talk about California water law, water rights, droughts, and a flood of different related legal issues, including environmental issues. So I hope you enjoy the program. And because you will be seeing this after this presentation, I welcome hearing from you if you have any questions or any kind of topics that come up, whether it's clients or in your personal or professional endeavors. I would be happy to serve as a resource. I do want to emphasize one point in that while I am focusing on California water issues, California tends to be very illustrative of what happens either first or close to first when it comes to water and environmental issues. Most of the time that ends up becoming a model that's used throughout the country and certainly within the Western states. And I do have a slide that'll generate an image and a map along the 100th meridian of our country. So with that, I'd like to proceed and give you a little background about myself. So we are a full service law firm. I'm based in Sacramento, but I'm also officed in San Diego. I have a statewide water practice. And what that really means is a whole lot of different things within a very nuanced practice area. And so water resources in California could be divided into what I call 3 large categories: water supplies, water quality, and finance, which deals with rate setting and financing for infrastructure projects. And so with that, I deal with surface water issues with streams and rivers, reservoirs, storage in reservoirs, as well as dealing with groundwater issues. And I will have a fairly lengthy discussion about the groundwater issues, because contrary to my prior statement a moment ago, that California often sets the tone for other states throughout the country, California was the last to implement a statewide mandatory groundwater program. And that is relatively new. So we'll talk more about that, but I deal with the surface water, the groundwater issues. And with that comes the second category of water quality. And that could be anything from the regulatory processes at the federal level to the state and local levels, as well as really a natural contaminant that occurs without being caused by human beings. And that impacts the water supplies themselves, which can limit the supplies and the water rights. That third category really is what's referenced there below, Proposition 218 and 26. And those were passed relatively recently with Proposition 218 back in 1996. It hit the water world in 2006. Proposition 26, I think, was passed around 2009 or 10 in California. And those are fraught with all kinds of litigation challenges, as there's a lot of uncertainty, there's evolving case law, and really it's one of those hot button topics here in California. So for our agenda, this will be really kind of the course description, although it doesn't say that, but the course description, as I would describe it, is here within the bullet points, is to really try to start with a broad level view of California's water system. So we'll start with a little bit of a bird's eye view of California water supplies, the different water systems, and from there really be able to get into some of the intricacies with the different agencies involved at the federal, state, and local levels, and their respective roles and responsibilities. And if time allows, we can talk about really even how those conflict sometimes. The jurisdictional issues become a topic, and there is a live issue now regarding federal and state roles and jurisdictions that's happening here in the Sacramento area. And then beyond that, we'll talk about the water rights a bit and water conveyance systems, as I mentioned. And then related to that are the environmental laws that really could and do oftentimes have an impact on water supply allocations, especially at the state water board level, as we call it here in California. There are equivalents like that from pretty much every state that I'm familiar with, which could be from Texas up to Colorado, and then moving west here into California. So there's huge complex regulatory schemes at the federal and state levels. And so we'll talk about some of those issues. We'll also talk about some of the other hot button topics, and that is really climate change. And when I mention climate change, certainly in a public forum, I always say I'm just the lawyer. I'm not here to opine about the science or causation. That's not what I'm trained on. What I'm trained to talk about is the fact that it is a reality from a regulatory legal perspective, and it does have implications to all water users. And I would say beyond California by far, but certainly here in California, it's something that we're seeing not only from a state level when you're doing environmental impact assessments for a development project, or wanting to try to acquire a new water right, and you have to go to the state and basically show what the impacts could or will be, and what are the alternatives to mitigate those adverse actual or potential impacts. This is something real, and we see this with our hydrologic cycle with the rain and lack thereof, or lower snowpack like we have in Northern California here, where it's been a very, very dry year. We're back into a drought. So we'll touch on these things. And so that's essentially the course description, is to really try to speak to water supplies overall, water rights, and some of the different environmental, regulatory, legal paradigms related to it. And it's an ambitious agenda, and this creates semesters worth of law school or graduate school types of presentations, or certainly at a conference. This can extend well beyond 1 hour. So I will do my best to try to give you an overview and touch upon some of the nuances, but my goal is to really address the topics and some of the subtopics and some of the related issues that come into play. So this is what I referenced a few minutes ago, the Great Divide at the 100th meridian. So I cannot pretend to be familiar with really a lot of things outside of California, although I'm pretty familiar with a lot of the Western states that are on the left side of the line there. And to the right, you'll see in a moment, and you'll see this throughout the presentation, that I have a number of different graphics to really try to literally illustrate much of what comes into play for what I do as a California water practitioner. But I think it's pretty common for a lot of others out there throughout this state and other states. And you'll see something where it really illustrates, in the West, we tend to be dry. I think most folks know that. But this is the Great Divide. I wish I could cite to the source of it. I cannot, but I give credit to whomever, whatever that is. But this really illustrates the Western states. In fact, behind me, you can see to some extent the books on my bookcase. Some of those go back to 1897 that I inherited from my mentor. And they really talk about the Western water rights law. But I will say, I know there are water issues throughout the rest of the country. I have received phone calls from practitioners on the Northeast coast where they had groundwater well issues and somehow they found me. But it's really, I think, a national issue, but it gets highlighted mostly for really the left side of this divide. This is the illustration I was referring to where East Coast looking at annual precipitation. And this is relatively recent, but it could be changing as it seems we have more increased drought cycles, more intense storms, but less of those storms. At least that's kind of the recent history in the last few years here in the Western states, certainly California. But the East Coast tends to have a lot more precipitation. And then you can see working from right to left that it becomes much, much drier. And looking specifically at California, you can see within the Central Valley, as we call it, those portions of the state where there's some of the largest agricultural operations in the world. And that helps California to rank anywhere from the 5th to 7th largest economy in the world. That's dry. And I have another figure that'll drill down another level to that level of operations, but it's a dry state overall, yet we have about 40 million people here in this state. So water variability and use. So this red line more or less is intended to illustrate this divide, and it creates a political and a policy divide to a large extent amongst regional and local agencies based on my experience and observations. But factually, 2/3 of the water supplies within California originate in the northern part of the state. Now, I would actually change this line that's suggesting the northern part of the state and move it down toward even below the blue line. We have just north of Los Angeles, you get to Ventura County and you start moving into what California characterizes as the Central Coast. But once you pass a mountain range called the Tehachapi Mountains, that's where everything, in my own personal opinion, starts to become Northern California, even though you're not truly in the north part of the state, because 2/3 of the water originates by those different lines or measures. It really does come down to originating in the north part of the state. Yet 2/3 of the water demands and use are needed in the south part of the state, because as many of you likely know, Los Angeles, Orange County, San Diego, Riverside, all these different counties within Southern California really create the population and most of the population within this state. And so what that creates is a need for conveyance systems, and we'll get to that in just a moment. Now, this reference in the lower left corner of this slide, referring to delta outflow, I will touch on the delta as it's referred to, and that's where the red line more or less is intersecting, and that's the San Francisco Bay Area. And that's just the natural flow and current flow, even under regulatory requirements, to have rivers feed the marshes, feed the San Francisco Bay. And it really is an effort to help push back the seawater, because it's so full of salinity that can be adverse to both fisheries and to agricultural operations and to municipal water treatment operations. So there are requirements that the state imposes, and that's pretty common. I've seen that elsewhere in other states, to where it's requiring water rights holders to essentially forego part of their water right to meet the environmental needs. And that's what creates so much contention, not just here, but certainly elsewhere, to having to have, whether it's a municipality, an irrigation district with farmers, farmers themselves, environmental interests, et cetera. The list goes on, to agree to basically give up part of their water right. So here I wanted to do a little transition to identify what are a number of overlapping topics. If we had a Venn diagram that would show the overlaps of, the different circles of, these criteria or influencers or forces that impact or drive California water. It really runs the gauntlet of anything from Mother Nature to regulatory decisions at the state level, federal and state levels, and certainly at the local levels, depending on what the policy issues are, what the water demand needs are, what the water quality issues might be, since there's tremendous variability throughout the state as it relates to all of those things. And so hydrology and drought, that's really speaking to like a dry year like we're having now, versus like the economy, you tend to swing back, hopefully, and start to have your wetter years. That's where you can store it in reservoirs, maybe groundwater, aquifers, which we refer to as groundwater banks. But population growth comes into play. There's the lifestyle choices. Do you have a large property? Do you still want to irrigate the big lawn? Or do you want to put in some dryscape or drip irrigation instead of the big sprinklers going? There's certainly the environmental needs, for fisheries and habitat. Infrastructure is a big deal, not only because it's expensive to maintain, but certainly to build. And to build, you also have the environmental impacts topic, and we'll talk a little bit more about that soon. So regional approaches, I think, is a good thing to have in mind. Building partnerships, I think, not only with your local partners or local agencies, and trying to create a common goal or common interest to where you can have some very candid discussions and really try to protect the water supplies, not only for customers or farmers or for fisheries, or a combination of all of those. And when I say combination, those are some of the most fascinating things that I work on, that I enjoy and take great pride and flattered by to be part of, with very sophisticated people that come together, identify their common ground and identify the uncommon ground, and then really work to resolve those issues. Governance is always a big thing, whether that's at the federal, state, or local level. It varies much here, and I'll get into this a little bit later, but it varies much here in California with governance, whether it's surface water, whether it's groundwater. There's what we call recycled water, which is basically wastewater, sewage water that has been treated to a certain level as required by the state. And many states have this. There are some federal related topics there too, but you treat it to a certain level so that it can be used for agricultural purposes, drinking water. And one of the most successful programs for that in the world is the Orange County Water District in Southern California. And I don't know if I have my facts exactly right on what I'm about to say, but years ago, I had heard from a very highly credible source that Orange County Water District was #1 in the world for doing it. Japan was #2. So it's a big topic about trying to be efficient with our water resources, especially as we have population growth. We have these environmental concerns. There's the cost and infrastructure, building types of issues. And then of course, climate change remains a theme throughout just about everything we do here in the water environmental sector in California. So a little bit about water rights. So here, there's really no way within a few slides I could really give the full due description or presentation or lesson about California's system of water rights. We have, I think, probably about the most complex system in the country, and that's because we have what's called, speaking to this last bullet point, a hybrid system of water rights. And what that means is most states throughout the country have a riparian water rights system, which refers to surface water, and often an overlying water rights system for groundwater. And in California, we treat that analogously for the most part, and I'll get into what that really means in a few minutes, but it's either one or the other, to be riparian / overlying or appropriative. And the short version of it is, if you have land that's lying over a groundwater supply, or you have land that's adjacent to a river. That makes you a overlying or riparian water right holder for the most part, respectively. Other states go strictly with the appropriative water rights system. And that means you're basically moving water from one parcel to another parcel. So the point A to point B is separated. Here in California, we utilize both water rights systems. And so that's what creates a lot of complexity when you're looking at who really has the right, which type of right is it, has it been what we call perfected or really, put to reasonable and beneficial use? And is it defensible? And when I think about that in my mind, I always compartmentalize what's your right and then how defensible is it? Defensibility refers to what extent you've complied with applicable regulatory reporting requirements, whether that's to a county or to the state or both. And that creates a whole set of nuanced topics. So I don't want to belabor that too heavily here, given our other content, but that's the system we have. It's unique, but starting at the top here on this slide, water is a public resource that belongs to the people of the state. That's stated within our California Water Code. Now, what does that really mean? You have a water right as, let's say, a farmer, an irrigation district that serves water to farmers, an industrial oil and gas operation, a city, whatever it might be. So really, do you own that water? And the short answer is you have the water right, but it's in a public trust kind of concept that California has developed over the last many decades, going back to our environmental movement back in the 60s and 70s when so many different environmental laws were passed. I think it was Professor Joe Sachs from Cal Berkeley, who has since passed on. He was one of the keys to really leading to what became some of the public trust and environmental doctrines that are still very much active and have evolved quite a bit in the last 50 years. Now, the second point about being able to have individuals obtain a right to use water or a water right, we call it here a usufructuary right. And so this goes back almost to the first year of law school, real property law, where you touch on some of these water issues, at least where I went to school. And it's this right to access to use the water. So you don't own the actual molecule of water, but what you do own is the right to access a certain amount of water for certain uses, and it might be limited by certain times of year, but it's really this real property aspect of what we call bundle of sticks. So it's something tangible, it's something real, and it's something that you have a right to treat as real property. And that's how it is treated here in California. Water rights are treated as being real property, as if you own it, like you own the building that you might be sitting in or the home, whatever it might be. Now, one of the, I should really say for the third and fourth bullet points, those are the two huge caveats, is that water rights here, and I think for the most part, this is probably a general theme out there elsewhere, is it's limited to reasonable and beneficial uses. Back in 1928, the California Constitution was amended to add Article 10, Section 2. And it's rather lengthy, but what it really talks about are these two bullet points here of water use has to be reasonable and beneficial, and you cannot waste the water. These are different legal terms of art that have evolved through case law. Reasonable is always a moving target, especially as we have drought cycles, conservation mandates. What is it to be reasonable? And for many of you who might be lawyers, that's just a theme that we're familiar with, where reasonable can take on different meanings on the same subject matter and even change over time, but certainly vary within different contexts. Criminal context under the Fourth Amendment, was it reasonable? Search and seizure. That again shows that there's a theme within just legal mantra and practices to ensure that there's a certain amount of reasonableness. Now, the beneficial uses, I think, is a little bit more easily defined. Under our California Code of Regulations, we have Title 23 that enumerates, I think, around 15 or so uses, whether it's municipal, irrigation, and it puts it more or less in a hierarchy, recreational uses, those sorts of things. And it's not an exhaustive list. I think that regulation even says so. Now, the waste of water is more of, I think, the safety net, because if you're not reasonably and beneficially using, are you presumed to be wasting water? And I don't think there's a case that explicitly says so, but I could certainly see that that would be an argument that someone raises. Types of water rights. So I've already highlighted a little bit about this with riparian overlying water rights. Appropriative rights, we'll talk more about. There's a distinction to understand there, which is what we refer to as pre-1914 rights or post-1914 rights. And the importance there is because it defines a jurisdictional issue as to what extent, if any, the State Water Resources Control Board, which is California's really enforcement and permitting agency, and for short, State Water Board, to what extent do they need to be involved with identifying and agreeing with a water right, or for a water rights transfer? I deal with transfers where we're trying to move water from Northern California to other parts of Northern California, or even other parts of the state. I do that for different clients. And the type of water right makes a big difference when you have to start going through the regulatory, tree branch kind of paradigm as to who do you need to consult with, who should you consult with, and ultimately, who do you actually have to get permission from? So we'll talk a little bit more about pre-14 and post-14. And the reason it's 1914 is because that was the year, or actually 1913 was the year that the California legislature passed what I think is called the California Water Commission Act, and which is now our water code. And it really, for the first time in California's history, a short history at that point in time of about 64 years or 63 years, was when the legislature decided, okay, we know we've had a lot of water rights holders, we know we've had a lot of water users since statehood, even before, but now let's create a state system that will look at appropriative rights so that we know who's using what, when, where, why, and how. Pueblo rights, these are fascinating. There's only a handful of them, and I'll touch on that a little briefly. But just think when the state of California came to be in 1850, there were existing water users, as I mentioned, and some of those were what was called Pueblo rights, and those originate from Mexican land grants. That was all part of that, rich and contentious history going back to California's formation. Prescriptive rights are a little more rare, certainly not as rare as Pueblo rights, but they do exist, and they do become like a real property dispute if you have competing water rights holders or landowners, cities, whatever the context might be. And it goes back to the real property idea of having to establish it by way of adverse possession. And so we'll talk a little bit about those elements, and I'll try to give you some flavor of examples that I've seen this actually come into play. Another fascinating type of water right here in California, and certainly throughout the country, and evident by its name, is the federal reserve right. And these exist with basically federal public lands, such as the forest lands, military bases, and tribal trust lands, so federally recognized Indian tribes. And this has actually been the type of right that's come to a little bit of the forefront, again, coming back to that California theme of how California often has something happen on the legal regulatory side that results in legislation and new law or a new case, that, whether state or federal, based here in California, that somewhat sets a tone or a model for elsewhere. And that did happen in the last several years, about 5 years ago with an Indian tribe in Southern California trying to establish a right to groundwater. And that was the issue. Does an Indian tribe have the right to groundwater as part of a federal reserved right claim? And the federal court concluded yes, and that has stood up. So this is an evolving area as well. But most commonly, we see riparian, overlying, and appropriative rights issues come up. So talking a little bit more about riparian, and I'll speed up and slow down on some of these slides and be mindful of time and getting through the slide deck. But with riparian and overlying rights, again, coming back to a real property theme and reality, is that it comes down to the parcel must be contiguous to some kind of surface water supply. And it could be a pond, but it needs to be, again, that tangible water supply source that you can see. And the same exists for the overlying right. If you're sitting over what hydrogeologists wouldn't be happy to hear me say, but this underwater bathtub, because it doesn't operate like a bathtub, it's just not the way the science and the geological conditions and characteristics allow for, and you could have people pumping too much groundwater from here and it affects others over here. But basically this underground bathtub, it's the same idea. So you're either right next to that surface water supply or right over it. And lands severed from a riparian parcel generally do not have riparian rights. So there are some nuanced topics with that, and going back to these old books, you could find some cases and, would need to shepherdize that very thoroughly given the age of the case or cases. But for the most part, the general rule is if you sever lands from that adjacent water supply source, then you've severed the right itself. Now, one big exception is, and I've seen this happen, you can have, let's say, a developer go in who wants to develop a residential neighborhood. And so it's probably, just call it 10 parcels and then subdivide it into 50 parcels. Well, in the chain of title and with the deeds, you can legally here be able to reserve that right within the deeds. But absent some kind of reservation, it's generally gone. So that's one thing, and one of those nuanced topics that people would need to be careful about if they're dealing with severing and dividing parcels up. Now, if they're reunited, that doesn't mean you automatically reunite the right itself, the water right. So again, that's where you have to have, very careful, cautious, thorough counseling and work done to ensure that what you're doing now doesn't cut it off from this point forward as time moves forward. So characteristics of the rights, it's again back to reasonable and beneficial use. That's common for every type of water right, whether it's the federal, prescriptive, pueblo, riparian, overlying, etc. And they're generally not quantified here. The only time they really become quantified is either by some kind of voluntary arrangement between water rights holders, just to be able to manage their supply locally, or more commonly, I think, is when there's a dispute, there's just not enough water, or someone thinks that someone else is using too much water, then sometimes that results in litigation. And there's a lot of that going on here. And that's where a judge is now forced to say, well, what's the size of the water pie? Who claims a right? How much do you claim and on what basis? And now, how do you allocate this? So as a matter of common law, these rights are not quantified typically, but when it comes to a dispute, or if there is a voluntary arrangement, that's where you tend to get into quantification. And one of the keys about these types of water rights is that they're not lost by non-use. Now, that's not true with appropriative rights, so we'll touch on that. But these are rights that are tethered and tied to the property and considered to be part of the property value. Otherwise, you might get into, I wasn't even thinking about this before now, but you can get into eminent domain and takings types of issues. That's certainly a topic that's likely to come up, when we deal with the groundwater management issues I'll be talking about. And what that means is local agencies are going to be telling cities or farmers and others to cut back their water use? Has that diminished their property value? Is it a takings? I think we're going to see quite a bit of that in the eminent domain practice area in the years to come. Now, riparians share in shortages of water. The same is true with overlying as well. It's considered a correlative right. It's a shared common pool. So there's not like a seniority between them for the most part. If one has to be cut back 10%, then the others have to be cut back 10%. And this is this bottom point on the lower right is just to speak to the reporting and defensibility concept that I mentioned about a water right. Is you want to make sure you're complying with the water code. And there are other code sections, but this is the key, is to just understand there are reporting requirements for just about every one of these water rights. Now, appropriative rights, this graphic here, there's the old saying that's attributed to Mark Twain, but hasn't been confirmed as far as I know. Whiskey is for drinking, water is for fighting. So here you can see you have two gentlemen, I'll call them, having a standoff and likely over some water supply issues. So this is a pretty common image that's circulates throughout the water world. But the appropriative rights, the mere ownership of land does not confer the right. So that's where I was talking about point A to point B. You're taking water from one area and moving it to another. So you're appropriating it. And government permission is needed, and that's from the State Water Board through a permit process, and that's the post-1914 process. So now what does that mean for the pre-14 process? Just even jumping down to this last bullet point. What that means is for the pre-14 appropriative water right holder, and it's built into the water code around water code sections 1725 and some others for transfers, and but there's various sections. But what it basically means is you almost operate much like a riparian or an overlying water right holder. So you're not seeking state regulatory permission for things unless you want to. Now, the catch becomes, there's probably several, but the biggest one would be you have to be ensuring that you're not going to injure other users of water if you do, say, a lease agreement to send that water somewhere else to someone else. Or if you're, that could be a transfer, that could be a permanent sale, but that's where you need to have the right team in place of environmental consultants, which would include anyone from engineers to hydrogeologists. It could be fishery biologists, depending on where you're looking to move from and to. Certainly legal counsel for framework and some guidance there. But the pre-14 right is a very valuable right. The riparian and overlying are extremely powerful, and the pre-14 are very close to that. But otherwise, you're looking to go to the state and apply, and it's quite a process. And this priority system that I mentioned here within the slide is that it's first in time, first in right. And I actually had a project about 10 years ago where there were two competing public agencies. I was representing one, and we were in a race to get to the State Water Board down the street from here. And the applications are not a simple thing to fill out. Again, it's a collective effort from the different types of expertise and professionals needed. And so we actually got ours in first, but it wasn't processed first. And so the other one was deemed first in time. So that was quite an interesting issue. And we worked through that. I remember rolling up my sleeves, and we kind of created an allocation system to figure it out and have a solution instead of having to go to full hearing. But it took about 9 years to get that figured out. So it's a very big deal when you're looking to get this post-14 right and having your paperwork done, your studies, whatever it might be, because the key and the because is because of this fourth point. In times of shortages, it's the most junior water users who are curtailed first. And this speaks to the drought subject matter in part for this presentation. When we're in a drought and we're under what's called curtailment orders, the state has required state water users, especially in the North State, because most of this water originates here, to cut back or stop diverting water depending on how junior they are, how senior they are. Were you looking to directly divert water? Were you looking to just take water that you'd already stored? That's where you get into all these nuanced topics. So it's a very, very big deal when you're talking about first in time, first in right, and how that collides with the drought time like we have now. And I think that curtailment set of orders from the state went out to, I want to guesstimate around 12,000 water rights holders here in the state of California. So other types of water rights, I'm going to move quickly through some of these things for the sake of time, not for a lack of importance. But the prescriptive rights, I always remember the elements of using a conjugated Spanish verb, haseo. And so prescriptive means you basically have exercised adverse possession and you've taken someone else's right, but you've legally done it if you can adequately identify these elements. So hostile / adverse, which means you're actually taking or using someone else's water. It's open and notorious. It's not like you're hiding and trying to be very, very kind of stealthy about it. And it's continuous, and this is a big deal, that it has to be for 5 years and not interrupted. And it needs to be exclusive. You were doing it for yourself, and the you being whether it's an individual, corporation, public agency, whatever it might be. I should mention, I don't have it on the slide, under our California Civil Code, and this might apply to other states, which I couldn't speak to because I'm only licensed here, but I think it's Civil Code 1005 or 1007, generally doesn't allow for prescription, whether it's real property, water, whatever it might be, against a public agency. And I think there's probably good public policy reasons behind that. If the local agency was more or less a little derelict, maybe, the public and its constituents and residents shouldn't be punished for that. So there's a little bit of an exception there. Pueblo rights, I mentioned a little bit. There's just those few examples. And moving on to federal rights, I've touched on that. I do have the example about Edwards Air Force Base in the Antelope Valley. I was in that case from about 2008 to 2015. It actually started in 1995 and became a number of consolidated coordinated cases, 2 class actions, almost a 1,000 square mile area of a massive groundwater basin being adjudicated. And Edwards Air Force Base has had operations there for decades. And there was a general who gave fascinating testimony about what their current mission is, what their future mission is. And I even turned to the Department of Justice attorney and I said, is that really okay to be talking about what the future missions are? But it gets into that very unique water right that's held at the federal level. And that's really kind of the extent of federal water rights, because there's not really a federal water policy per se when it comes to water rights, but there is this right. Uses of water, I'll just focus on, it's self-evident from the images, except from the pie chart. So this pie chart, the point that I would want to emphasize is that it's really indicating that 50% of California's water supplies are dedicated to environmental needs, whether by way of regulation, court orders, voluntary arrangements, with the other half being 40% going to agricultural, and then only 10% is used by urban, municipalities. The water is coming out of your taps at home, the office, commercial uses. So that's a staggering statistic, because so often here you hear, because of the large farming operations, that it's farmers who are basically hogging all the water. And I'm not trying to be biased for or against any kind of use, but that is much of the stigma that exists, but the numbers speak for themselves. I'll move quickly through these statistics here, but we have a number of different dams at the federal and state levels. There's others at the local level. But one interesting note is, what is an acre foot? That's often how we measure water. And there's different metrics. Engineers like to use cubic feet per second, CFS, or gallons per minute, GPM. But often it's measured, especially at higher quantities, by acre foot. And so 1 acre foot of water typically can take care of a family of 5 up to 1 year. And here I mentioned a soccer field, but I always kind of think of it as a football field where it's 1 foot deep. So it's a large amount of water. But when you look at the other numbers, we have millions of acre feet of water, at least ability to store, and typically pretty good supplies other than a year like this year. This is a rather quick illustration about the different types of water systems. So we have the Central Valley Project. So that's a federal project that was built here in California, and they probably, I think, had it elsewhere, certainly from the western states and including California, that started around the 1930s. You have the State Water Project that started around the 1960s, and the two projects kind of interrelate and interconnect with one another. And this goes to my point from earlier, that this is what speaks sometimes to the jurisdictional disputes or operational disputes between the federal and state government, where how do these interact? Who needs to operate to which way? Who has the obligation to take care of endangered species or environmental issues? And so that's a live issue that's actually happening. There's current litigation between the federal and state of California governments dealing with a lot of these types of issues. So hopefully that gets resolved sooner rather than later, because it impacts the rest of us as water users, environmental interests, and certainly those trying to service those interests, such as me. Hetch Hetchy is the city of San Francisco, county of San Francisco's system that starts down on a different river system and but kind of works to the middle part of the state. And they basically transport their water from the Western Sierra to all the way over to San Francisco. Moving south, you have the LA Aqueduct. So that's part of the LADWP project. Just think the 1974 movie Chinatown with Jack Nicholson and Faye Dunaway. That's pretty illustrative of moving that water from, again, like Hetch Hetchy, from hundreds of miles away to help feed, a thirsty and growing and large region. The Colorado Aqueduct actually is owned and operated by Metropolitan Water District of Southern California, and that's moving water from the Colorado River, obviously starting in Colorado, and moves through some of these western states. And that's part of what I'm trying to illustrate here, is you have this Colorado River basin, and it ultimately, as you can hopefully see at the very bottom, drains into the Sea of Cortez between Baja California and the country of Mexico. And it tends to only be a trickle at this point, but there's a whole lot of complex issues beyond California that come into play. There's the Native American Indian tribes along the river, with a lot of them with a lot of rights, and certainly agricultural interests, municipality interests. So it's really, I think one of the key points is this is a very intertwined, and it's cliche to say, but it becomes really kind of a ripple effect. What happens with one impacts another. The Delta of California, I mentioned that, is rich farmland that really helped drive and create California's history of agriculture and growth from an urban level, agricultural level. And this is where you have the two largest rivers in the state flowing into it. The Sacramento River, that has a lot of tributaries. One of the tributaries is the American River, which I do a lot of work on. And then you have the San Joaquin River that also has a lot of tributaries. The Tuolumne River is one of those, and I'm fortunate to be able to work on those projects as well. Federal agencies involved, there's numerous, but these are probably the more common ones that you see, and they each have their jurisdictional role. And for the most part, I don't think have too much of that Venn diagram of the circles overlapping and stepping on each other's toes. Now, they might not always agree, but they do have their different roles. So the U.S. Bureau of Reclamation is under the Federal Department of Interior, and they're really the owners and operators on behalf of the federal government who operate the federal reservoirs. So that Central Valley project that I mentioned has several reservoirs within the state. One is called Folsom Reservoir, just about 20 miles east of where I am now. And They do a lot of the work to try to live by their water rights and also have their customers slash contractors receive the water that can be delivered. And that becomes very, very challenging in a dry year like this year. Army Corps of Engineers does more of what it sounds like, the engineering. And it can be anything from having a gravel bed project and you're looking to help create fishery habitat. We have the salmon that migrate up through the Bay Delta and up these rivers. And so there are certain regulatory requirements to follow there before you start doing a project that's well intentioned, but you need to still have that approval. And Federal Energy Regulatory Commission, that comes often a topic when you're dealing with hydropower projects, which are throughout the country, and we certainly have a number of them here within the state, throughout the state. And so FERC definitely becomes one when it comes to licensing compliance. And then you have the National Marine Fisheries Service. They're the ones who oftentimes federal agencies, state agencies, and stakeholders go to when you're looking to develop what's called biological opinions, because you're looking to do something with the habitat or the water supplies, and you need to understand the full impact of what those would be. This is the federal agency that specializes in developing its input and opinion about what would happen, what should be done, what mitigation can be done, et cetera. And U.S. Fish and Wildlife Service overlaps with that as well. So I've already spoken to you about the Central Valley Project, and so I'm going to speed some of this up for the sake of time. State agencies, we have what I mentioned, the State Water Board. There's also Department of Water Resources, which is an agency that measures, it does a lot of different things, but it measures the snowpack several times at really kind of the beginning of the calendar year to get an assessment as to what water year type it looks like we will have, which then helps inform these other agencies and in turn water users as to what kind of year and planning you need to do. Can you do a transfer to help someone out if you have supply and you're not being curtailed, and be able to get it to them? Becomes a win-win, becomes a business deal, and then it becomes a habitat. It's actually a win-win-win, because you have a business deal that's good for the person transferring water to get revenue, and then it becomes a win for habitat and fisheries, because it's more water that's flowing through the rivers now until it gets to the buyer. And the buyer is now the third win, because they're getting the supplies they need for their uses, whether it's urban or agricultural. State Water Project, I've already mentioned, but fascinating infrastructure. And as I mentioned, so much of it is very intertwined. Local agencies. Now, regional water quality control boards are not truly local agencies. They fall under the State Water Board, but there's 9 of them throughout the state of California, divided up by region, given the size of our state. And what they do, they focus mostly on the water quality aspects, as the name suggests. And that can range among a host of different topics and issues: enforcement actions, permitting to be able to operate a food processing plant, or discharging water over here. So there's always this regulatory overlay anywhere we look around here. But truly, the local agencies, the local water and irrigation districts. And so, again, that could be counties, cities. Irrigation districts are farming districts for the most part. And there's going to be some overlays there where I deal with that quite often. You could have, let's say, a farmer-to-farmer transfer program that allows farmers to transfer water between one or another, but they're water rights that are actually held by the irrigation district. So there needs to be an agreement. There needs to be some oversight about that. But it's not often as contentious or as thick with regulation as it can be at certainly the state and federal levels. Reservoirs, we need more of them here in California. We really do. And I say that because I will show you an illustration in just a moment, but we have a number of reservoirs. This is mostly illustrative of certainly for the top 2/3 of this graphic of the federal government's Central Valley Project system and the state's State Water Project system. And the numbers are very low, especially in a year like this year, but that's all the more, much like a bank account, the more you could save, the better you are for that lack of a rainy day when we do have our drought cycles. Groundwater is such an important topic that is very top of mind here for many practitioners, many water users and agencies, because California did not regulate as a statewide mandatory program groundwater until three pieces of legislation were passed in 2015 to take effect in 2016, which is quite remarkable that it was really just kind of left to a free-for-all, or there might have been some areas, there were, that had what are called AB 3030 programs, but it's basically a groundwater management program that is designed to proactively try to manage the water supply for the good of the users and for the good of the basin, so that it's sustainable and it's there for the long term. So this really kind of, well, here's a statistic. Groundwater accounts for almost 40% of California's water supply. Now, these numbers fluctuate depending on the kind of year you have. When you're in a dry year like this, water users tend to use groundwater more often than surface water, because the bank hopefully has enough in there, the groundwater, even if it's not an official groundwater bank, but like the banking account at your financial institution, hopefully that's a good backup supply. And then during the wet years, you rely more on the surface and let the rain and the snowpack melt off and recharge that underground aquifer. But going back to this legislation, it's called SGMA, and it's the Sustainable Groundwater Management Act. And what it's really designed to do is to require local agencies, public agencies, to come together for 127 different basins throughout the state of California, and for those agencies to recognize which basin are you in, who are you going to work with, form what's called a Groundwater Sustainability Agency, this GSA reference in the fourth bullet point, and then develop what's called GSP, a Groundwater Sustainability Plan. And what that plan has to do is to ensure that 20 years from now, that basin is back in a healthy state. It's not being overdrafted. Again, back to the financial banking account kind of analogy. You're not taking more out than that's going in. And the problem is, in many areas, more has been coming out than going in, which has created a whole host of issues and what really drove the legislation. So as part of the legislation and regulations that have come out, there are what are called these 6 critical parameters. And the idea is to, the short version is to just stop the adverse impacts. And these are the types of adverse impacts. Now, not all of these are occurring in every basin, such as seawater intrusion. There are many basins that are inland and not close to the ocean. So you don't have to worry about that. But these are the things that these local agencies / GSAs need to look at to develop their plan. And then it gets submitted to the state for what is essentially approval. The state regulations don't call it approval, but that's basically what it is, because the state does become what the regulations call a backstop. So if local agencies are not getting this done adequately or in time, then the state will step in and create their own plan. And virtually universally, local agencies do not want that. Some related environmental issues. There's, at the federal level, NEPA, the National Environmental Policy Act. Here in California, we have our CEQA, California Environmental Quality Act. And then you get into the Federal and State Endangered Species Act. And then there's also the Clean Water Act. And I failed to include the state equivalent that's called the Porter-Cologne Act. So there, and then of course you have this more or less wild card. There's not a whole lot of this in California, but the National and State Wild and Scenic Rivers Act, that's actually part of our local American river just down the road from here. And it's beautiful. But the first 4 are really what show the federal and state mirrored paradigms that exist that so often are intrinsic when you're dealing with water supply issues. Meeting environmental demands. vary from these in-stream needs, which means keeping water in the river at certain flows or at certain temperatures to ensure that it's the best set of conditions for certain types of species of fish. And that varies, and that's where you need a fisheries biologist and a very competent one to really speak to a lot of these issues for in-stream, and similarly for wildlife refuge. Problems with drought. I'm going to move quickly over this one to be able to respect your time for 1 hour, but also try to highlight, again, something I mentioned before, where you can see where in the central part of this state, it's the driest part, but also has some of the largest agricultural operations in a lot of urbanized areas. And that's just really the natural condition that's coupled with changes in hydrologic cycles, changes in regulatory decisions, changes in human uses of water, whether it's cities, agricultural users, whomever it might be. This is designed to really just emphasize about drought here in California with our reservoirs, and this is why I think we need more reservoirs. It's just you really want to be able to store for the rainy days, and current conditions are very poor. The red lines tend to indicate what the average tends to be. The blue bar within the yellow bar is illustrating where we currently are. So there's a lot of these reservoirs that are in very, very low conditions. These are illustrations just showing where things were during wet years, where things were during our last drought. Fortunately, the Folsom Reservoir that I mentioned that's close by is not at this state yet, and we are working hard to keep it that way. This illustrates the diminishing snowpack over a 5-year period taken for the same times, and you can see just how much less there is in March 2015 compared to 2010. And again, another illustration that shows the 12-year time span. This is speaking more to the climate change aspect and reality from a regulatory reaction and perspective as to how California has changed so much in 12 years based on images like this and new rules that came out. Persistent drought. It comes and it goes, just like economical cycles, but there's severity, and you could see a little bit more of that with the dark brown from 2015. So next steps, I think creativity is the way to go. We're dealing with a limited resource with increasing demands, increasing regulatory pressures, new case law that's giving more jurisdiction to state agencies. And so it's a very, very challenging, quote unquote, environment. And so we have to constantly be thinking ahead. I think trying to build partnerships is a great way to go because it just really helps avoid the litigation and the fights. And if you have to do it, you have to do it. But I think creativity is really one of the keys. And part of that is identifying different water sources. Recycled water, like I mentioned, and an amazing operation that Orange County Water District does is a great example. Desalination plants, we have a couple of those here in California. San Diego County Water Authority has one down in Carlsbad. But I think the real key from an individual level, whether it's you or someone you work for or might work for, is learning what are your water demands now and into the future, and then developing the right team of professionals. You want to identify what are your water supply sources now, what are your options now, what are your needs and options later, and then really getting together the right people and professionals to really prophylactically make sure your property valued, or your plant operation, or your city customers, your farmers, whomever it might be, they're in a lower risk category for having to deal with continuing challenging circumstances. So with that, ladies and gentlemen, I'll end there, and want to thank you for your attention and time. And again, just renew my invitation to reach out to me if you have any questions or would like to follow up. My email address is wes.miliband, M like Mike, I-L-I, band, B-A-N-D, @ AALRR.com. So I appreciate your time and attention, and I hope you found this helpful. Thank you.